Good morning. Thank you for joining us for this first panel of the morning. The title is Presidential Powers and the Bush Presidency. I wanted to thank our distinguished panel of experts on stage, my colleagues joining us this morning, as well as the audience. After the conclusion of the presentation, we'll have a chance for Q&A, so we look forward to your participation. Also, as a matter of housekeeping to begin, please silence your cell phones. And to start the morning off, I'll give some brief introductions, then the speakers will come to the stage to give their papers. To my left first is Dr. Lewis Fisher. He's a senior specialist with the Congressional Research Service at the Library of Congress. He began work with CRS in the 1970s and served as the research director on the House Iran-Contra Committee in 1987, writing major sections of that final report. Dr. Fisher also frequents the Hall of Congress, testifying on various issues ranging from war powers, covert spending, and CIA whistleblowing. He is the author of over 15 books, including his most recent work, The Constitution and 9/11, Recurring Threats to America's Freedoms. Dr. Fisher has taught at a number of different universities around the country, including Georgetown University, American University, and Johns Hopkins University. He received his doctorate in political science from the New School for Social Research. To his left is Dr. Dale Herspring. Dr. Herspring is a University Distinguished Professor in Political Science at Kansas State University. He is also a visiting professor at Kansas University. Dr. Herspring has numerous books. His most recent is with the University of Kansas Press just this year, entitled Rumsfeld's Wars, The Arrogance of Power. Dr. Herspring created the political, military, diplomatic lecture series at KSU, bringing over 130 senior academics, retired military, and diplomatic officials to campus, providing graduate students with an open forum to discuss current problems in international relations. He's taught at various institutions, including the National War College, Georgetown, and the University of Maryland. Dr. Herspring received his undergraduate degree from Stanford University, a master's from Georgetown, and did his PhD work at University of Southern California. And finally, we have Dr. Mitchell Sullenberger. He's an assistant professor of political science at University of Michigan in Dearborn, just a few hours away. He's recently authored a work on congressional power and the presidency, entitled The President Shall Nominate, How Congress Trumps Executive Power. Dr. Sullenberger has also served as an analyst in the American national government for the Congressional Research Service. In addition, he is a member of the American Political Science Association and a reviewer for the journal Political Science Quarterly. Prior to arriving at the University of Michigan, he's accepted teaching positions at George Mason University and Bowling Green State University. Dr. Sullenberger did his undergraduate work at Fairfield University and received an MA and PhD in politics from Catholic University. We will begin the morning with Dr. Lou Fisher.
I have to amend my introduction slightly. I was at the Congressional Research Service from 1970 until 3 years ago. I'm still with the Library of Congress, but I'm with the Law Library, where I'm a specialist in constitutional law. And I still do the kind of things I always have done. We're each going to take 15 minutes and have plenty of time for your questions. I want to talk about the president and war power in terms of source of authority and how well the Constitution is protected. And I'll give you 4 categories. The first 3 categories, to me, protect the Constitution. The last category does not, and the last category involves George W. Bush. The first 2 categories are easy. We're all familiar with express powers of the president. You can read them. That's expressly given. The Constitution also provides for implied powers, namely powers that can be reasonably drawn and derived from express powers. Typical one for the president, he has the express powers to see that the laws are faithfully carried out. If some cabinet head interferes with that, he has an implied power to remove the cabinet head. All 3 branches have implied powers. More controversial is the third category, emergency powers, but if used in a reasonable way, I think the Constitution is protected. And here I'm thinking of Abraham Lincoln in April 1861. He exercised emergency powers. Congress was not in session, but he never claimed that he acted constitutionally or legally. In fact, he said that to Congress when he returned, what he did, whether strictly legal or not. He wasn't making a case that he was acting strictly legally or constitutionally. He also told Congress that I don't think anything I did was beyond your powers. So he's admitting that he was using both what he has under Article 2 and what Congress has under Article 1. And much more importantly, he came to Congress for that purpose and asked that Congress consider legislation to retroactively approve what he had done. And if you read the debate, Congress understood that he had no authority to do what he did and that he needed retroactive authority, and that statute was passed. So those are three categories of presidential power: express, implied, and emergency, all of them capable of protecting the Constitution. The fourth category is inherent power. George W. Bush was not the first to invoke it. Certainly President Truman claimed he had inherent authority to seize steel mills in 1952 to prosecute the war in Korea. That was struck down by the Supreme Court. He did not have that inherent authority. President Nixon claimed that when Congress passes appropriations, that he has an inherent power not to spend all the money. He could spend half of it, none of it. That was an inherent authority. And there were probably 80 court cases. The administration lost all but 2, and the one that went to the Supreme Court, the administration lost that. And when I came to Congressional Research Service in 1970, there were 3 professional articles written on this subject, impoundment of funds, and I had written 2 of them, so I immediately started to work with Senator Sam Ervin in the Senate, and we had hearings, and a tall, lanky guy from the Justice Department came to testify. He had long sideburns. I don't know if any of you know who I'm talking about, but it's Bill Rehnquist. So we got to see a lot of people early in their careers. And Congress passed legislation in 1974 to put restrictions on impoundment. So a lot of presidents have gone through this claim that somewhere in Article 2 there's some kind of inherent power. And the reason that inherent power is dangerous to the Constitution is that the claim is that if you're exercising inherent power, there can be no check against it. There's nothing Congress can do, there's nothing courts can do. But from what I've already told you, inherent powers have been challenged and pushed back by both statutory means and by judicial opinions. Another problem with inherent is nobody knows, including me, what it means, inherent. If you look it up in the dictionary, inherent has something to do with intrinsic to something or in the nature of something. So in terms of a constitutional system, you have just walked out the door on that once you talk about inherent powers. So let me talk about what this administration has done. This administration by far has pushed inherent powers more than any other administration, and to a great extent, unfortunately, successfully. I'll explain what I mean by that. Let's start with military tribunals. Interestingly, George W. Bush came to Congress after 9/11, got a statute to go against military activities in Afghanistan, got a statute in October 2002, military action against Iraq, got a statute for USA Patriot. And yet, after 9/11, on November 13, 2001, Bush issued what was called a military order authorizing the creation of military tribunals. So they did not come to Congress for authority. They claimed that was inherent. And we have had year after year after year of litigation and legislation. I myself wrote 3 amicus briefs during this time for the Hamdan case that got to the Supreme Court in 2006. And I wrote a book, Nazi Saboteurs on Trial. That was the 1942 Supreme Court case, Ex parte Kieran. That got me interested in tribunals, so I did another one. It's called Military Tribunals and Presidential Power, going from George Washington to the present time. So I got very interested in the source of authority for tribunals and how effective they've been.